So the draft that we put forward is a comprehensive substantive code for sexual assault, and it's sort of loosely divided into different clumps of provisions. So I can kind of walk through each. First is 213.0, which is the definitional section. And this is important for two reasons. One is that prior to that, we opened the code actually repeating what we think of are some key concepts of the 1962 model penal code that we are carrying forward into this code. And we repeat that explicitly at the start of 213.0, but we actually felt it so important, we literally reproduced the black letter so that anyone who gets the black letter package can immediately see this is the background, mens rea, causation, other kind of high level principles, what is an act, et cetera, that are applicable in interpreting our code. Then in the definitional section itself, we have to define some really key terms. I think one of the most surprising aspects of this process for me was to learn how few jurisdictions had actually tried to define consent, possibly the most contested, difficult concept in sexual assault, one in which, you know, there's wide variation of understanding, and you would routinely see judges give instructions to jurors who come back and say, what's consent? You know, use your common sense, and good luck with that, because what we learned is there's a lot of different common sense understandings of consent. And so we passed a definition of consent at an earlier annual meeting. It was a really, I think, beneficial debate, both in the process of drafting what was proposed, as well as in the subsequent amendments and ultimate adopted provision. The core of the offense of sexual assault is to intrude upon someone sexually, you know, aware that they're not willing, aware that that you lacked consent. And so that core definition was then built upon with, here are the other situations in which the absence of consent is aggravating, or in which you might have what nominally looks like consent, but that as a matter of law, we consider ineffective consent. So if I put a gun to someone's head and say, do you want to have sex with me? You know, think carefully before you answer, and they say yes, you know, that's not consent. We all recognize that's ineffective consent, even if, you know, on the face of it, you have what looks like a yes or what have you. Similarly, if someone's unconscious or someone has been drugged without their knowledge, that's not consent, even if, you know, someone says, well, they didn't say no because they were unconscious. We can recognize that as both an aggravating circumstance and one in which the principle of consent doesn't work. Consent also doesn't work when it comes to child offenses, because we don't ask, did a 4-year-old consent to sex with their parent or sex with an adult? We might get into consent as the child gets older. You know, can a 16-year-old consent to a 16-year-old? We say the answer to that is yes. But, you know, you still might say, well, a 15-year-old can consent to sex with a 15-year-old, but they can't, as a matter of law, consent to sex with a 45-year-old. So we kind of built out a statutory structure that looks to aggravating and special conditions around sexual encounters to determine the statutory language. So let's walk through each of those provisions then. The first is 213.1, literally that goes in order, point 1, point 2. And point 1 is really meant for force situations, where when we're talking about physical force, sometimes people use force and they mean what we call coercion or extortion or other kinds of psychological pressures. When we say force, we say physical force, because we want to convey a physical threat to the body or the physical harm caused to a body in order to extract sexual submission. And that also is point 2. Point 2 is a lesser form of force. Point 2 also encompasses, because that punishment for the point 1 offenses is so serious, it's a 2nd-degree felony and a 3rd-degree +5 felony. We heighten the mental state there to knowledge, because we felt we really want to get people who know, you know, they are aware with practical certainty that what they're doing is this high level of force or unacceptable behavior. And that is what deserves the most serious sanction of all. If someone is merely reckless as to the use of aggravated physical force, or if they are reckless or knowing as to the use of physical force, a lesser standard of force, then they're punished in point 2, which is addressed to these, again, lesser degrees of force or higher degrees of force where perhaps it was not as obvious that the force was being deployed, or the person was aware of a big risk of it, but wasn't as deliberate. The next category, the point three offenses, are really all about people who are vulnerable in one way or the other. And the most serious is the subsection for section one, which is people who are incapable of consenting because of the condition they're in. They're either asleep or unconscious, or they are essentially drugged surreptitiously, drugged by someone without awareness of being drugged for the purpose of engaging in sexual assault. The next category is for people who are more partially incapacitated. It's not fully incapacitated, but they're sort of partially, or they're vulnerable in a special way. And it covers three or four categories, depending on how you look at it. One category is persons with mental disabilities. And this was a tricky one because we want to respect the ability of people with mental disabilities to engage in sexually fulfilling relationships, consensual relationships. And yet we also know that this is a class of people who are often targeted for victimization deliberately. The second general category here is the passing in and out and a substantial incapacity. This is meant to address the very common scenario. Most people, especially in the ALI, think of college students, and many of these cases are not, in fact, college student cases. They're working people who go to a bar and become intoxicated, and then a sexual assault occurs, or they have a party with friends and the sexual assault occurs. And so a lot of times it's not alcohol, also it's drugs. People use drugs, and then a sexual assault occurs. Some of those cases, people will be fully unconscious, but there's a non-trivial number of cases in which the testimony is basically passing in and out of consciousness. And then the last is a category that is novel in the law. This doesn't have, it has a little bit of traces in existing law, but it's a fairly new provision. And it's really reflective of what you see in a lot of cases out there, which is individuals who've taken their clothes off to receive a professional service, most commonly a massage, but all sorts of other types of services might require nudity of some kind. And then the actor engages in an act of penetration. And the weird thing about these cases is that they're not these kind of ambiguous encounters where it's an escalating pattern of intimacy, and or even that this is a social environment like a party where people might raise questions about, well, were you really incapacitated or not, or did you really consent or not? Or it's a pretty unambiguous situation. Somebody goes and they pay for a massage, or somebody goes and they pay for a medical exam, or they go and they pay for some kind of other treatment that requires nudity. And the actor takes advantage of that situation to penetrate the person sexually. And it falls into a consent frame in the absence of a provision like this, which just feels like the entirely wrong set of questions. And then the last is another common provision in law, which relates to custodial relationships. Obviously guards and inmates are the most common, but all sorts of custodial probation or probationee, et cetera. And those are just relationships that on their sort of face are inherently coercive, and that law has broadly recognized to make consent essentially impossible. The next section, point 4, is the extortion section. This is about coercive non-physical threats. Again, this is most commonly threats to report immigration violations. If you don't, you have the landlord who comes to the tenant and says, if you don't engage in a sexual relationship with me, I'll report you to ICE, or other kinds of threats that, although nominally consensual, again, the person will say, okay, fine, I'll have sex with you if you promise not to do this terrible thing, are illegitimate the same way as if they'd come to you and extorted money. The next point 5 is prohibited deception. This is a pretty narrow category of cases, although there are many out there. I think everyone is very familiar with the Nassar case, the gymnast who claimed to be treating girls for injuries, but in fact was engaging in sexually predatory behavior. This is people who either are deceiving another person as to a medical necessity for a treatment, or who are deceiving another person into believing that it's someone known personally to that person. So again, this is, there are many advocates who want a much broader provision, who say deception is always impermissible. And I think while that might be the kind of standard you teach your children or you think is ideal for the world, it's too broad as a criminal prescription. So deception is an inherent part of sexual encounters, whether it's that these are not in fact my real eyelashes, or I didn't in fact graduate top of my class at Harvard, or other types, I'm very wealthy or I will be, or what have you. Deception is, for better or for worse, a common part of the sort of sexual dance. And so although it may come to be at some point that that is considered unacceptable, it was just strayed too far from norms to try to as a practical matter or a theoretical matter to punish that kind of deception. Then we have the consent provision, which has two dimensions to it. Both require a lack of consent. Consent, of course, as defined in 213.0. One is an aggravated offense, a fourth degree felony. It's still a low level felony, a 5-year felony, but more serious than the default provision, which is a 3-year felony. And the 5-year felony is for when either someone's overriding an express no, expressions of unwillingness, whether that's physical, pushing someone away or what have you, or verbal, no, stop, don't type things. Or when it is so sudden and unexpected, they didn't have an opportunity to express unwillingness. And so you do get cases of a burglar, say, breaks in and goes to the bed of a sleeping person. And as the person startles awake, so they're not asleep, there are many cases in which the burglar begins to have a sexual encounter and the person wakes up to the sensation of the sex. But there are also a number of cases in which the person is startled awake and they're shocked because this is not what you expect. And then the sexual encounter occurs. And if the burglar never makes an explicit or implicit threat of force, which is often the case, I mean, there are those who would say just showing up in someone's house without permission is implicit force. But generally that's not what the cases hold. It falls into this consent framework traditionally because the person is awake. And so the question is, in that instance, if someone fails to say no, is it sort of better treated as a no case or better treated as a lack of willingness case? And we say essentially that if you're so shocked and you just didn't expect this to happen, and so you didn't even have a chance to say no, that's equivalent to actually verbally articulating a no. All right, the next cluster of cases are about sexual contact. Here I would say it's a real challenge because most of the sexual contact cases are cases in which a stranger is engaging in contact with another person. We all know of stories of groping on buses and trains and things like that. So trying to make sure that we were navigating a standard that would allow for sexual contact when, we didn't want to make every kiss illegal, right? Stealing a kiss at the end of a date is a very different thing than stealing a kiss on the subway commute. And so trying to address that in the statute, I think, was a challenge that we hopefully arose to the occasion. The next cluster is the sexual assault offenses for children. Those are loosely divided into the sort of age-based category of 0.8, incest offenses, defined fairly narrowly because many of kind of classic cases like an uncle will be dealt with under just age-based. And so this was really meant to deal with people who are essentially acting as parents, people for whom an accusation of sexual assault implicates the future of the child because it's where they live, it's who feeds them, it's their intimate family member and so forth. And so it's more than just age that's an aggravating factor, it's the relationship of nurturing that children depend on family or in loco parentis figures for. Exploitative assault, which is meant for this kind of ring of older actors who take advantage of their position vis-a-vis people who otherwise can consent, meaning 16 and 17-year-olds, minors who otherwise are of age, but that you might want to protect from exploitation from adults in their sphere that could use that statute or that sort of standing. And then the last is fondling and contact offenses with children. And then the 0.9 is meant to cover sex trafficking. It's an area of recent activity. It's really meant to get at a separate set of concerns from sex work generally. It's meant to get at coercion to engage in sex work or the use of minors in sex work. And that was really inspired and a lot of help was given to us by some of the recent work that's been done in this area. Statutorily, we benefited greatly, although I think this particular set of provisions definitely differs from some of the existing federal and other statutory schemes in ways that we feel better balances between what you might think of as kind of ordinary sex work, whether it should be legal or illegal, versus coercive sex trafficking. And then we have provisions, lastly, that are related to kind of defenses and the ancillary issues. So 0.10 puts forward what you might think of as the bondage defense or BDSM defense. It's basically a defense for the use of force in a consensual manner. This is a provision that's engendered some controversy as well. It's increasingly an issue. And This is meant to protect the sexual liberties of people who want to engage in this kind of non-serious bodily injury sex play, while also safeguarding those people against exploitation and harm, and safeguarding people who don't want to engage in that behavior from a claim that they did in fact consent. And so it heightens the requirement for consent when it requires specific consent to specific acts of force or violence, and precludes force or violence that is that causes serious bodily injury. And so we had input from representatives of the BDSM community who, first of all, were very welcoming of a provision like this to protect their membership, because there is a sense that their membership is preyed upon at times by people who want to engage in non-consensual encounters and don't respect the boundaries of the relationship that are laid out, and that there's no recourse, because once a legal actor like a prosecutor finds out this person engages in BDSM, they're like, forget it, I'm never going to prove my case. And so giving greater structure to what is a legal versus impermissible sexual encounter involving violence and threats of violence. And then also providing a structure that the community itself is very accepting of, which is an affirmative consent structure. This is a community that does have norms of kind of sex positive articulation of what they are and are not going to engage in and do. And so to say, here's the safe word that we're going to use so that when I really want the boundary to be drawn, or here's the kind of violence I accept and here's what I won't accept, that kind of protection when that communication has taken place. And then lastly is the sexual registration provisions. These are so broad and sweeping, I think I'll leave those for another time. But we were responding here, I think, to two impulses. One is the universal presence of sexual offender registries in law. Most of those, however, on the other side, we think are excessive. They're punitive, they are retrograde, they actually harm more than help. There's all sorts of empirical work that shows that they lead to higher incidences, not lesser incidences of public safety and so forth. So we tried to devise a scheme that respected the public safety rationale, but also maximized everything we know from the recent social science and other evidence-based findings about what is the most constructive use of registration. We were, responsive to critiques that registration itself is an outdated mode and that we should instead take a strong stand against it. For reasons that are given in the commentary, that was not ultimately where we ended up, in part because I think there's a real thirst for guidance on how to scale back registration provisions, but not necessarily eliminate them entirely. And many people who are strong advocates for even robust registration schemes. So I think that section shows an attempt to kind of balance those considerations. And that is the code.